Hello, this is going to be a brief review of state disability insurance and paid family leave. These along with these along with unemployment insurance are managed by Employment Development Department. In the case of state disability insurance, it pays for the employee when the employee can't work because of their own illness, injury that's not work-related, or pregnancy. SDI pays up to 52 weeks of benefits. Now this is paid for, as is paid family leave, out of your own paycheck. There's a deduction that you can see on your pay stub. There are eligibility requirements, and the employee fills out a form by pretty much going online to EDD. So part of our job in HR is to make sure that they understand that they have to apply for the coverage. There's a 7-day waiting period for this benefit. So paid family leave provides 6 weeks of benefits as opposed to the 52 covered under SDI. The problem with paid family leave really is its title. It's called paid family leave. It is not leave at all. It is simply money. So it works within the employer's leave of absence policy. For example, if an employee works for a company that has less than 50 employees, there's no CFRA leave or FEMLA leave, and so the employee may need time off to take care of a child who is in the hospital. Well, if the company has a leave of absence policy that covers that, the employee can take the time, and then they can collect the money through paid family leave. But again, it is only money. There are similar eligibility requirements as with SDI, and there is again a 7-day waiting period. Now that 7-day waiting period does not come into play if the employee is transitioning from pregnancy disability leave to leave to bond with baby. The employee simply would transition from SDI to PFL. Also, as employers, we can require that the employee use up to 2 weeks of vacation before granting this leave, personal or medical, and thereby allowing the employee to collect PFL. We don't have to do that, but we can. Paid family leave again pays when the employee is unable to work due to the need to care for someone else. Those relatives are defined under the law. PFL is not a leave, and PFL works within the employer's leave policy. So perhaps the employer does not have a policy that covers time off to take care of a child who's in the hospital because they have 6 employees and the only leave of absence that they give is pregnancy disability. Well, in that case, the employee would be possibly laid off. They could still collect PFL because they can't work due to that situation. And then when the dependent is once again able to work on their own or live on their own, the employee would then be able to collect unemployment because they are now once again looking for a job. Paid family leave does not extend or expand in any way the employer's policy. Doesn't have any requirements that the employer provide the time. Those are all separate laws or lack of law because the employer isn't large enough. It does not create job protection rights. It does not create any guarantee to return to work. It is an extension of SDI. When the law passed, SDI was just increased a bit in the amount of the extension. And again, it is entirely employee paid. That may change some point in the future, but as of right now, the employee is the only one who pays for this insurance. The idea is all the employees in California pay into this fund, and some employees use the fund when the employee needs to take time off from work. Paid family leave benefits are payable at the same rate as SDI. There's a formula that EDD uses that can be found online. It's pretty much 50 to 60% of the employee's income. Frequently, employees use other forms of income. for example, vacation, accrued, or sick time, to interact with SDI and PFL in order to increase their take-home pay. Employees cannot receive PFL at the same time that they're receiving workers' comp, unemployment comp, or state disability. It's pretty easy to see why that would be the case, because all of those provide income for different reasons. So, what kind of care is covered under PFL or paid family leave? Well, to care for a seriously ill spouse, registered domestic partner, parent, or child. And in 2014, those definitions were expanded to include grandparents and grandchildren, siblings, in-laws, and so on. And of course, the parent, child, etc., all cover various versions of that, such as foster parent, adopted parent, de facto parent, and so on. We can require that the employee provide us with a doctor certification of the need for care. Of course, we don't ask for any sort of diagnosis. And we can require the signature of the person who is receiving the care, or his or her authorized representative, such as power of attorney. PFL for baby bonding is a bit different in the sense that you do require proof of a new child, such as a birth certificate or adoption papers. Normally, in real world, you would have this because the woman would just have transitioned from pregnancy disability leave and SDI to PFL. But it's possible that the father could be taking time to take care of the child, in which case you can ask for a birth certificate or adoption papers. It includes adopted, foster, and newborn children, and it has to be used within 12 months of entry into the family. So the child does not have to be just a newborn. For example, a woman might transition from pregnancy disability leave right to return to work. She has her mother or another relative taking care of the child. At 6 months, she decides that's not working out. She wants to put the child into daycare or spend some time at home with the child. She can do that. If the child is adopted or foster child, then they must be under 18 years of age. Okay, that's it for now. We'll be moving on to workers' comp.